YouTube content creators are having a real hard time right now, and their videos are getting demonetized, they're getting strikes, and they're essentially under attack right now. If you fall within the categories of being an educator, a reaction channel, this video is for you. Today, I'm giving you a real lawyer's reaction to how I deal with copyright claims. This is on David Bennett's YouTube channel with 1.2 million subscribers. And here's what we're gonna accomplish together. One is to talk about how to deal with these claims, what's happening, to give you some of the best strategies that my law office actually uses, but then also to give you the text that you can use when you are counterclaiming, as well as if you need to reach out to the actual claimant who is fraudulently filing claims on your videos. If that all sounds good, be sure to subscribe right now and let's jump into it.
So let me start by explaining how the Content ID system works, what it even is. So when you upload a video to YouTube, if it contains a copyrighted song, so basically a song by a well-known artist released on a record label, it will automatically be detected and demonetized. And this is before you've even released it. You know, you've uploaded it, but you've not published it. It's automatically been spotted that there is copyrighted material on there, and it's been demonetized, and the money is now being funneled to the copyright holder.
And the reason this is the way things are done is because each of the major record labels have deals directly with YouTube, and the deals often are if people upload content containing our stuff, such as someone doing a cover song. So they're covering a popular, famous song, and they haven't obtained what's called a synchronization license in order to do that. So then what the record label does is, instead of just taking down the video and going after the creator, they just claim all of the ad revenue. Now again, where this has become problematic is that where major record labels and companies that are not allowed to be collecting the revenue, where they're actually filing manual claims. So he's talking about Content ID now, where it's just in the system and it's automatically getting claimed, again, pursuant to existing contracts. We're going to dive deeper into the actual problem, but let's keep going.
In usual YouTubing, you know, outside of the world of educational YouTube, this makes sense, right? If someone used your song as like background music, or just kind of like as a feature in a video, you'd feel like you deserve some sort of reimbursement for that, right? But with educational content, there's this concept, this doctrine known as fair use or fair dealings, where you can use short, selective clips of copyrighted material in an educational setting without getting permission. You can do that and you can still earn money from it, right? The problem is YouTube doesn't know that when you upload it, so you have to effectively tell them. So that's the next step. We've received this copyright claim on our video. We've not released it yet, but if we do release it, it's going to be demonetized. So what we do is we go on to the menu and we choose dispute. And this is something I didn't do for years, much like what Beato has been discussing in his recent videos, where he, for years, just kind of accepted that he would get demonetized and just thought, well, at least I'm not getting blocked. I can still have the videos out there. I'll just, you know, make money through other means.
Not just Beato, but Beato said up through November of last year, he just would let whoever claimed the video take the monetization. But the reason why it's important that content creators on YouTube actually push back is that if you do qualify for fair use, we're going to talk about how you qualify and how that works. But in Rick's case, enough is enough. If someone comes and takes the ad revenue from your video that you are legally entitled to earn, to keep, they're doing something that does not comply with the law. So you absolutely have the right to push back, and you should.
When I first started my channel, you know, the content I wanted to make had to involve using copyrighted clips of music. And I quickly found that I couldn't monetize it. And I didn't know that I could do much about it. I knew that there was this dispute function here on YouTube, but the language they use, you know, YouTube uses when you're filing the dispute is very scary. You'll be, you know, your channel could be terminated if you abuse this tool, if you file a fraudulent claim. So it makes you feel like, okay, I'm not going to worry about that. I'm just going to earn some money maybe through Patreon, through sponsorships, make the channel make ends meet somehow other way. But, you know, after a few years and in a few videos getting quite a lot of views, I was thinking, you know, I'm leaving a lot of money on the table here for videos where surely I should be allowed to use these clips. This is fair use.
Okay, so what he talked about is basically stage one of this is there's no real risk to your channel in someone files a claim and you can push back. If you push back, then you go into this 30-day window where the claimants can either decide to withdraw their claim or they can say, no, I'm standing by what I submitted. And lo and behold, the majority of the time, the claimant is going to double down and be like, no, 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 my claim is valid. So it pushes you then into this kind of level 2. Level 2 is where now there's a lot of risk. And that's what he's talking about. We hear so many YouTubers discussing that they're so scared of this process because of the potential penalties. You might have your channel terminated, you might get sued, you might get strikes, and it's because of all those kind of forewarnings that a lot of people just back out and they don't even go through this process. But especially for the clients that I work with who have been through this and now they see the game that the major record labels and these other companies are playing, they have a different way of approaching it that we're going to talk about. Pursuant to the Copyright Act, this is in section 107, there are 4 factors that are considered when looking at whether fair use applies. The first is going to be the purpose and character of how the copyrighted thing is being used in the new video. So let's pretend that David is doing a cover song, and he's doing a cover song, and that song is covered by the license that the major label owning the song has in place with YouTube. Then he would be permitted and okay to post that cover song video here on YouTube. Now, if he then goes through and he explains how he created it, and he shows the different sounds, and he's using the lyrics, and he's using the sheet music, and he's using different elements to now make it an educational piece to explain what it is that he is doing. Each section has to be analyzed into how it is being used. So let's focus on the educational piece. If we're going back to our 4 factors, 1, how is he using it? The purpose and character of the use. Is it commercial in nature? Are you making money from it, right? Profit of some kind? Are you doing it for non-profit educational purposes? Actually, there were courts that even looked at how non-profit entities can still do something for a for-profit outcome, and that affects the analysis. But that's not the end of it, right? Just because you're making a profit from it or having it in a way that benefits you doesn't not make it fair use. So we go to factor 2, like what's the nature of the thing that you are using? So in the realm of, reacting to a popular song or using it to educate, the nature of a song is that it is expressive. It is something that invokes emotion. It is not like a fact. It's not saying, hey, I put all these facts together into an online course. And in fact, creative stuff like songs get more protection. 3, the amount that was used, right? Are you essentially, let's say, playing an entire song all the way through and at the very end you're like, and this is an example of a 2000s song, right? That's not going to be terribly transformative in that, well, you have made it into something new technically, but how much you used in proportion to you making your educational point really does matter. And then lastly, what's the effect? Are you hurting the open market, right? The value of the original? Maybe you are taking it and you're transforming it into something that is damaging to the original. And I'll tell you what the major labels claim is that they go, well, for these reaction channels, because you are just simply reacting to the new Drake song and you're not transforming it in any kind of way, you are usurping, you are taking all of the views that we would have gotten on the Drake video. And you are therefore hurting the market of the original song and video.
Demonetization is still in place. Everything is where it was at the beginning. So as I said before, no penalties. But of course, you haven't really fixed your issue. You haven't managed to monetize your video. So now you have another option, and this is where it can get dangerous. You have the option to appeal. Now, appeal is kind of just disputing again. You get a slightly bigger box in which you put your justification in.
So guys, this is what we were talking about with now you are at level 2.
But the big difference between appeal and dispute is that appeal has ramifications.
That's right.
Has negative penalties if you're rejected.
That's right.
So when you file your appeal, there is now a 7-day window, not 30-day, 7-day window for them to respond. And if that 7 days expires, then just like with the dispute stage, you win automatically. Fantastic. But if the copyright holder responds within that 7-day window, yes, they might say, okay, fair enough, it's yours, have it, and it's unlocked and you get the money. But what they might, and probably more likely, are to say is, no, we still think our copyright claim is valid, so your appeal has been rejected. And if your appeal gets rejected, you will get a copyright strike. Now, you've probably heard of copyright strikes on YouTube. You can have 3 copyright strikes concurrently on your YouTube channel. And if you get those 3, then your channel is suspended.
That's a pretty scary thing. So this is a big reason why a lot of creators do not fight back. But here's the thing. I've had creators who have done this so long and they have been essentially bullied and harassed by these major labels so frequently that now what they do is that they go through to this kind of second step, which is the appeals process. They file the counter notification and they go, really what these labels have to do is that they have to sue me. So it's a game of chicken. What some have shared is that they don't think the major labels are going to follow through because they were just trying to do this as a money-making tactic of just attaching to YouTubers' content and banking on the fact that YouTubers are going to be too scared to really fight back. But if you do that and you play that game of chicken, there is that risk that you are going to get copyright strikes on your channel. And let me put it this way, because even for Rick Beato and all the issues that he is having on his channel, I mean, if you lose your channel gets suspended, you then have to go have this fight. And even if it was done in violation of copyright law, because there are rules saying that a major record label cannot just come and file a claim fraudulently, a copyright claim fraudulently on your channel. And if they do, they have to pay you for your resulting damages, your attorney's fees. But the harsh reality is that in order for you to then fight, because your channel got disputed, you have to file the lawsuit, and then you have to win, and then you have to go through all this process and hire a lawyer. So the risk to creators is absolutely there.
I've had 1 strike at any given time before. But over my YouTube career, I've had about 5 strikes. And the reason for that is that strikes actually only last for 3 months. If you get given a copyright strike, you can kind of just wait it out. And 3 months later, it will go away, which is what happened to me with my very first strike. But another thing you can do if you get a strike is when you get issued the strike, there's a email address you get given of the person, the correspondent at the copyright holder who issued you the strike, who rejected your appeal. So you can actually email them personally and say, hey, I'm just the guy in a bedroom making YouTube videos, educational content. This is my livelihood. The channel is very important to me. Please, will you consider revoking the copyright strike?
I love that he mentioned this. Do this every single time you go through the copyright system on YouTube, but you need to also directly reach out to the claimant. And then the templated language I'm gonna give you, you include it in your email. And in fact, why don't we do that right now? All right, take a screenshot if needed. All the stuff in red you can update, but this is fair use language. It includes the case law as well as different statutes. So you say, Universal has improperly filed, let's say, a content ID claim, and it was on my channel. Put in your channel name there. It was for this video. It was for on this length of time, which is this length of time. But you go through and just say, this was for commentary, criticism, education. I only used as much that was absolutely needed to make my educational point pursuant to the Copyright Act. Fair use applies. Here is some case law talking about how YouTube videos and fair use apply. Now, we've seen some creators talk about how if you have 2 claims, to be a little bit cautious with how you manage this, but there are things that you can do to minimize the likelihood of the claims. There are some YouTubers who have simply stopped using songs and videos in their reactions, and they will just talk about it because they just don't even want to deal with any of that. Others will use, again, just the very limited amount that they absolutely have to. Some use videos and not the actual audio. I've seen some people use the audio portion, but they talk over it while it's playing. But I would say the strongest basis for you is that every time you use someone else's copyrighted stuff in your videos, to consider the 4 factors pursuant to 107 that I went through, because that's what's guiding all of this for the record labels and their lawyers that are looking at this. And so you having a good faith basis for what you're doing and you actually applying that analysis is going to give you the strongest position for success. If you guys found this video helpful, be sure to subscribe. I'm Miss Crystal, and I'll see you on the next one.